We got a question.
Good morning, Your Honor.
All right, good morning. Um, Can we just put the attorneys on the record for the juvenile, or the parties, I should say?
Your Honor, may we request that the camera be turned off for the juveniles?
Right, good morning, everyone. I'm Judge Jackie Powell, and this is first appearance court. Today, I will let you know if I've determined probable cause from the police reports I read this morning, and then we will also talk about release conditions. Today is not your trial date, neither is it an adversarial hearing, and so because of that, I encourage you to speak with your attorneys before trying to speak on the record. Everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the attorneys from the Public Defender's Office, in the courtroom with me, I have Mr. Brian Reedy. Over at the main jail, Mr. Hector Romero, and these attorneys are available to those of you who are at the other facilities by phone. So please make sure you speak with your attorney. Those of you represented by private counsel, your attorney will come to the court and address your case from here. If your attorney's not here, you can let me know, and I will try and see if I can reach out to that attorney. But please don't tell me you have private counsel unless you or your family have retained the attorney for this recent arrest. Just because an attorney represented you in the past, or maybe is even representing you on a current matter, does not automatically mean that they are representing you here today. Also in the courtroom with me, I have the attorneys from the state attorney's office, and I'm going to ask those attorneys to please announce themselves on the record.
Kayla Bramnick for the state.
Kesha Davidson for the state. Nathan Joseph for the state.
All right, thank you. And then we have representatives from confinement status, pretrial supervision, the clerk of courts, and all these persons are here this morning to help with the morning's hearings. They can provide additional information if needed. Those of you who are here facing municipal ordinance matters or misdemeanor matters, you may be able, and I say may, be able to resolve your case here today. It is all going to be dependent on what's going on with you personally, all right? Those of you who are facing felony charges and violation of probation matters where your judge have already signed a warrant with a no bond hold, those cannot be addressed at first appearance. After today, if you don't already have an assigned judge, your case will be assigned to that division. And then moving forward, any pretrial motions, if you end up going to trial, those matters will be heard by that division judge. All right, before I start calling the names, there's someone who signed in for Sean Foster on page 18. Is that, he's not going to be here. His case has been sent to his division. So it's not gonna be on this docket. You'll have to go to the division. Somebody can check the docket and tell them what division they need to be in. It's Foster on page 18. It's been sent to Division FY. Okay? All right. There are some persons at the jail has asked to call out of turn, so let's begin with Lawrence Stephen.
Right here, sir.
All right,
Good morning, Judge.
good morning. Mr. Stephen is before the court on one charge of touch or strike batteries, domestic violence. I find probable cause.
Judge,
All
I
right,
understand that the
hold on a minute. State,
Sorry.
whoever is speaking, you're gonna have to use a microphone, because if, the further you are, the harder it's gonna be for me to hear you.
Thank you.
Your Honor, Kesha Davidson for the state. The state is requesting $1,000 bond, no victim contact.
Okay?
Judge, we're going to be seeking pretrial release for him. He's receiving disability, and that $1,000 is the amount of his monthly income. I understand that his son is going to leave today. I understand the son's the alleged victim in the case. Mr. Stephen has lived here his whole life. He's 59 years old. For the last 30 years, he's lived in Pembroke Pines. And again, he receives disability due to some lung and back issues. Because of the same residence, we'd ask for pretrial release for him.
Does Mr. Stephen have any prior criminal history?
Yes, Your Honor. 2000, 2013 trespass, he pled no contest. 2013 trespass, pled no contest. Burglary, decline. Criminal mischief, decline. 2011 disorderly intoxication, pled no contest. 2001 battery, pled no contest. 1998 possession of cocaine, dismissed. DUI, pled no contest. 1998 possession of cocaine, decline. Possession of drug paraphernalia, decline. That's the extent of his broad crimes.
Grant the ROR to pretrial supervision. Mr. Stephen, your attorney is going to give you the information for the pretrial. You need to go there no later than tomorrow morning to sign up. If you don't sign up, if you don't go and sign up, a warrant will be issued for your arrest. Do you understand that? Then the
Yes,
next,
Your Honor.
then the next thing is that you need to know that there is a no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, Your Honor.
All right.
Thank you, Your Honor.
You're-
Thank you. Happy New Year, Your Honor.
Same to you.
What? Go that way, sir.
All right, Randall Cooper.
Mr. Cooper, come on up. Good morning.
Well, Your Honor, Happy New Year.
Happy New Year, Mr. Cooper. Mr. Cooper, you are before the court on one charge of touch or strike battery. It's domestic violence.
Yeah,
I find probable cause.
yes.
Your Honor, the state will be requesting $1,000 bond.
Okay, and does he have any priors?
Yes,
Any
Your Honor.
the recent domestic or violent charges? Sorry?
As a 2014 resisting officers without violence, adjudication withheld. 2012 resisting officer without violence, adjudication withheld. 2002 burglary, declined to adjudicate. Aggravated assault with deadly weapon, adjudicated guilty. 2001 resisting officer without violence, that was dropped. And he has a 2006 possession of, he has a 1992 burglary on, adjudicated guilty.
Madam Clerk, what page is Cooper on? Page 7. Okay,
Page 7.
all right. Yes, Mr. Goldberg.
Yeah, Judge, I'm sorry. We're having a real difficult time hearing what's going on in the courtroom today. I think the state asked for a $1,000 bond, but Judge, we'd be asking for pretrial release for him. I don't know if the court saw, but he came up. He's on an oxygen tank. He's got advanced COPD. He was actually just discharged from the hospital 2 days ago where he had spent a week. He does not live with the alleged victim. He's lived here in South Florida for the last 50 years. He lives in Sunrise by himself for the last 40 years in the same condo. He receives disability. He's a retired electrician. And he has his aunt and his uncle and some cousins in the area as well.
All right, so the only issue I have with the information that he's provided you is that in this probable cause affidavit, it says that they both live together. That the victim and the, sir, please don't say anything. The victim and defendant live at the above address in a tent behind the establishment. The defendant and victim live in this tent as a household.
She lives there.
And the allegations that, he got angry because she refused to give him her, her deposit, a direct deposit card, and that the victim said the defendant stood over her and struck her on the left side of her face above her eyebrow with a closed fist. She stated that the defendant then struck her again 2 to 3 times in the face with a closed fist. She sustained a large hematoma over her left eyebrow bone. All right, and she was seen by fire rescue. Based on those allegations, I am going to leave the $1,000 bond in place, no victim contact, and sir, that means no phone calls, no text messages, no social media, no third-party contact. All right, Schneider Jean Noel.
His grandmother is present, Your Honor.
grandma's in that courtroom.
All right, so Mr. Jean Noel is before the court on one charge of aggravated assault with a deadly weapon. It's domestic violence. Number 2 is touch or strike battery. Number 3 is criminal mischief, over $1,000. Number 4 is a violation of misdemeanor probation. And I find probable cause for these charges. All right, state.
Your Honor, it looks like he has a number of misdemeanor priors. He also has a 2010 possession of cocaine with intent to distribute, And based on the allegations, the state would be asking for a $2,000 bond on count 1.
Okay, Mr. Goldberg.
And no victim contact, of course.
I'm sorry. Judge, Mr. Jean Noel believes that count 4, the violation of probation, he thinks that period is over, is terminated.
Okay.
Just before I go as to count 1. So can we verify that, if that hold is valid?
It's a 2017 warrant. All right. For our purposes here today, Mr. Goldberg, it appears that is still active, that warrant.
Okay.
Okay.
Very good,
Yes, and
thank you,
it
Judge.
also appears, Judge, as though the warrant is for failing to pay court costs.
Okay.
Judge, he says that he's gonna go stay with someone else, with his family. He's lived in South Florida since he was 4. He's now 30 years old. He works as a counter sorter for Osco Uniform Company. He's had that job for the last 3 months. He makes $9 an hour. So he's gonna try to post whatever bond the court set. We're also gonna ask for a photo order. He's got some injuries, and a phone order as well.
All right, Mr. Reedy, did you indicate that he had family members here?
Yes, Your Honor, his grandmother? His grandmother is present.
Is there something you wanted to say?
Anything you wanted to say to the judge? You can step up here.
Judge,
Good morning, ma'am.
how you doing?
I'm well.
Happy New Year.
Same to you. Is there something you wanted to say in regards to your grandson?
Yeah, my grandson.
Okay, that's it? That's all you wanted to say?
I don't know. I want to burn him out. I don't know how much discussed.
All right, well, that's what we're talking about right now, so I'm going to decide in just a few minutes how much total bond he will have, okay? All right, okay.
Figure.
So the allegations that I have said that Mr. Jean Noel intentionally struck the mother of his 3 children multiple times with his knee and fist, threw her to the ground. Defendant threw a metal razor scooter at the victim's head, attempting to strike her. He then smashed out the driver window and rear driver side passenger window of the victim's vehicle with a rock. And post Miranda, he admitted to smashing out the windows of the vehicle and the home. All right, and based on these allegations, I am going to impose a $2,000 bond on charge number one. He has a $1,000 bond on two, a $500 bond on three, which will remain, and a $500 bond on four. I'm ordering no victim contact, and it looks like he has a status hearing tomorrow on the violation of probation matter, okay? And then Keegan Swisher. I believe Mr. Swisher is on page 21.
He's coming up right now, Judge. He's on page 21. He's going to need a photo order.
Okay, Mr. Swisher is before the court. Charge one is carjacking without a firearm or weapon. Number two is failure to obey police or fire department. I find probable cause for these charges.
Judge, it looks like he has a pending warrant for simple assault. He also has a number of priors out in Pennsylvania, including escape. Based on that and based on his the allegations, the state is requesting a $10,000 bond on count one.
Mr. Goldberg?
Judge, we're okay with the state's recommendation.
Is Mr. Swisher's residence in Pennsylvania?
Yes, Judge.
His allegations that the victim that was at a gas station, the passenger was still in the vehicle. He was sitting inside the passenger seat while stopped at the gas. As he's waiting for his friend to come out of the store, subject jumped into the driver's seat, pointed what he believed to be a gun under his shirt at him, and told him to get out of the car. The subject then began driving away, and it was at that point that the victim Rodriguez jumped out of the vehicle. He was the one who called law enforcement. I guess there was no firearm found. To this community, and no victim contact, no return to that location.
I'm sorry, Judge, could you repeat the bond amount?
20,000. All right, on page 6, Parker Kenneth Smith, someone signed in on that case.
He's coming up now, Your Honor. Good morning, Your Honor.
Good morning. Mr. Smith is before the court on one charge of touch or strike battery.
They're in the process of hiring.
And I find probable cause.
Judge, I understand that Mr. Smith is hiring a private attorney.
All right. All right, good morning, folks. Have you hired private counsel? So you haven't. So this morning he's here. You don't have a private attorney as yet. He's entitled to counsel, if he so desires. Otherwise, he can represent himself for this hearing if he so chooses. So that's the first thing. I just need to let you know that he is entitled to counsel. If you don't have private counsel, he can speak with the attorneys from the public defender's office, or he can represent himself, whatever he chooses. So, Mr. Smith, what are you doing this morning? Are you using the public defender, or are you representing yourself?
I'm using the public defender, Your Honor.
Okay, all right. Mr. Goldberg, you already had an opportunity to speak with him?
I have, Your Honor.
Okay. So he's charged with touch or strike batteries, domestic violence. I find probable cause, state?
The defendant has no sort of priors, but given the facts of the case, the state will be requesting a $1,500.
Okay. All right, folks, you heard that? Are you gonna post his bond?
Yes, we're gonna post
Will
his
you,
bond.
are you able to afford the $1,500 bond?
We are.
All right,
The only thing if we would add, Judge, if it looks like the court's gonna go along with that, is just a photo order, so he's got some injuries.
all right, but he may not be there long enough for you to take.
I know, and it's an abundance of caution.
All right, so $1,500 bond, no victim contact. No victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Smith?
Yes, Your Honor.
Okay.
Yeah.
All right, that's it, thank you.
We'll go that way.
All right, the Spanish interpreter is here for what case?
Judge, Mr. Morales on page 22, but I understand he's got private counsel. And then there's also,
Perez on page 19.
Mr.
Detention center or contact. One of the satellite courts needs Spanish
and
interpreter
also,
also.
I'm sorry, Carlos Perez on page 19 also is
And then there's somebody else?
Yes, Judge, one of the satellite. I think it's North Broward needs a Spanish
In
interpreter.
North Broward, do you need a Spanish interpreter? If you'll let me know who that person is? Who, what, for who?
Page 2, Orozco.
Mr. Sherman, you here for Mr. Morales?
Orozco?
On page 2, Orozco. Ovia, first name or middle name? He's on page 2.
I hear the name, I just don't see the paperwork.
Okay.
Right, so I don't see the paperwork. Oh, I have a port now. Paperwork for probable cause for purposes as well. I don't see that. But, all right, so, come on. All right, do you swear or affirm to interpret from Spanish to English and English to Spanish?
Yes, I swear.
And please state your name for the record.
Yes, Sandra Bryan.
All right, so let me address Carlos, who's that, Mr. Goldberg?
I'm sorry, Judge, this is Roberto Morales. It's
Okay.
the very last case on the docket. I understand that Mr. Sherman is representing him.
Okay, all right, so let's address Mr. Morales on page 22.
Scott Sherman on behalf of Mr. Morales and Mr. Morales' sister is present.
El señor Roberto Morales, lo represento, y la hermana del señor Morales está presente en el tribunal.
All right, Roberto Morales is before the court this morning
Roberto
on
Morales está delante del tribunal en el día de hoy.
charges 1 and 2 are sexual assault by family custodian, victim
El cargo
over
1 y 2
12.
es de agresión sexual como custodio de un pariente familiar.
And actually, number 3 is the same charge.
Ese es el mismo cargo.
I find probable cause for these charges.
Encuentro que ha habido causa probable para estos cargos.
All right, and then I'll hear from the parties at this time.
Honor, it doesn't appear that he has any priors, but,
All right, hold on just a moment. At the main jail, Mr. Goldberg, if you could turn the microphone, thank you, thank you. All right, yes, state.
Your Honor, the state is asking that you find proof evident presumption great, considering the charge the defendant was the stepfather of the alleged victim.
El Estado está pidiendo que su señoría encuentre que ha habido pruebas evidentes y presunción grande, dado que ha sido él el padrastro de la víctima,
And we're asking that you hold him no bond.
y que lo detenga sin fianza.
Mr. Sherman?
Your Honor, the state's request is without merit. There is no other than the allegations of the alleged victim, there is not sufficient evidence for the court to find that the presumption is great or that the
Lo
proof
que
is
alega,
evident.
lo que alega el Estado no tiene mérito. No hay ninguna base para que el Estado pida que ha habido ninguna presunción grande, no hay suficientes evidencias.
Mr. Morales has resided in Broward County for the last 19 years.
Señor Morales ha vivido en el condado de Broward por los últimos 19 años.
He works as a roofer.
Él trabaja arreglando techos.
To my knowledge, he has no prior criminal record whatsoever.
A mi leal entender y saber, él no tiene ningún antecedente penal en absoluto.
As his sister could tell the court, he has a separate and independent residence that he can live with his sister away from the alleged victim.
Según lo que indica la hermana, tiene una residencia y una dirección completamente aparte donde él puede residir, aparte y separado de la alegada víctima.
The court has a less restrictive alternative. The court could place Mr. Morales on level 2 house arrest.
La corte tiene a su disposición una alternativa menos restrictiva, lo puede poner bajo el arresto en el domicilio.
With a level 2 monitor, order no contact with the victim or her mother with whom the victim resides.
La corte tiene a su disposición que le puede imponer un monitor electrónico a nivel 2 sin tener contacto ni con la víctima ni la madre de la víctima.
Again, without me to repeat myself, the defendant has no prior criminal record. He has substantial ties to the Broward County community.
Como dije, no me quiero repetir, pero el acusado no tiene antecedentes, no tiene un antecedente penal y tiene enlaces en la comunidad.
He has 2 brothers, 2 sisters
Tiene 2 hermanos, 2 hermanas,
that have resided in Broward County for a substantial period of time.
quienes han residido en el condado de Broward por un tiempo sustancial.
And again, the only thing alleged in the probable cause affidavit are the unsubstantiated allegations by the alleged victim.
Y de nuevo les repito que en el affidavit de la causa probable, lo único que aparece ahí son alegaciones sin sustancia, sin apoyo ninguno.
And again, that is insufficient for this court to make a finding that the proof is evident or the presumption is great.
Entonces vuelvo a repetir que esto no es suficiente para que el tribunal declare que ha habido una presunción grande ni que ha habido evidencias probables.
I'm asking the court to release the defendant on pretrial release.
Estoy pidiendo que el tribunal deje salir en libertad al acusado bajo los servicios previo a juicio.
The court is very familiar with the legislative presumption in favor of releasing the defendant on non-monetary bond.
La Corte bien sabe, conoce bastante bien la legislación en cuanto a la libertad bajo la supervisión previa a juicio.
And finally, Your Honor, I had the pleasure of appearing before you several months ago, and the court was already familiar with the 4th DCA's position with the 4th DCA.
Gotta interpret.
Como usted,
Sorry,
can you
4th
repeat
DC
that again? I'm sorry.
the 4th District Court of Appeals.
Como he tenido el placer de presentarme ante su señoría anteriormente en otras ocasiones y usted bien conoce the 4th DCA,
4th DCA,
el cuarto DCA,
where the 4th DCA has regularly held, Your Honor, that depending upon the financial circumstances of
que
the
como usted bien
accused,
sabe que el cuarto DCA ha dictado que depende de las circunstancias financieras.
excessive bond is tantamount to no bond.
Si impone una cantidad excesiva de fianza es igual que estar sin fianza.
And again, I respectfully remind the court that the court has a less restrictive alternative.
Y respetuosamente les recuerdo al tribunal, a su señoría, que usted tiene a su alternativa una opción menos restrictiva.
The court can require the defendant to reside with his sister,
La corte puede ordenar que el acusado resida con su hermana,
not return to the residence of the victim,
que no regrese a la residencia de la víctima,
have no contact directly or indirectly with the alleged victim
Que no-
or her mother,
que no tenga contacto ni directo ni indirecto con la víctima ni con la madre de ella,
and place an electronic monitor on the accused.
y colocarle un monitor electrónico en el acusado.
If the court wishes to hear,
Si el tribunal desea escuchar,
2 members of my client's family are present in court.
hay presente en el tribunal 2 miembros de la familia del acusado.
Since they are obviously very upset, I will proffer that they will testify that they love their brother very much,
Como obviamente están bastante afectados, yo sé que ellos testificarían que aman a su hermano muchísimo,
that as the probable cause affidavit indicates, my client is going to take these charges very seriously.
según indica en el affidavit de la causa probable, mi cliente va a tomar estos cargos bastante en serio.
He is not a flight risk.
Él no corre riesgo de huir.
His release from custody does not pose danger to anyone.
Su libertad de la custodia o de la detención no impone ningún peligro a nadie,
Particularly if the court places an electronic monitor on him.
particularmente si el tribunal le coloca un monitor electrónico en el acusado.
And again, I remind the court that this is a 42-year-old man,
Y de nuevo les recuerdo al tribunal que este es un hombre de 42 años,
19 years in Broward County,
lleva 19 años en el condado de Broward
and no prior criminal record.
y no tiene ningún antecedente penal.
Having reviewed this probable cause affidavit,
He revisado el affidavit de la causa probable
at this time, the court will not make a finding of proof evident presumption great.
y en este momento la corte indica que ha habido pruebas evidentes, presunción grande.
State if you wanted to speak further as to the bond. I know that Mr. Sherman has said a lot about, otherwise, it's up to you. I just don't know if you wish to say something else.
Then, Your Honor, the state is asking for 100,000 on each count.
Entonces, su señoría, el Estado pide $100,000 en cada cargo,
Obviously, no victim contact,
obviamente sin tener contacto con la víctima
pre-trial GPS.
y con un monitor electrónico previo a juicio.
If I may respond very briefly, Your Honor.
Si puedo contestar brevemente, su señoría.
If the court wishes to inquire, the defendant will testify that he has no money in the bank.
Si la corte quisiera indagar, el acusado testificaría que no tiene dinero en el banco.
He does not own any property that he could sell or use as collateral
No es dueño
for
de
the posting of a bond.
ninguna propiedad que se podría utilizar su valor para prestar ninguna fianza.
He does have a full-time job as a roofer,
Él tiene sí un trabajo de tiempo completo como techero,
but like most of us, he lives paycheck to paycheck.
pero como la mayoría de nosotros, él vive de cheque en cheque.
I realize that the allegations contained in the probable cause affidavit are very severe.
Yo me doy cuenta y reconozco que las alegaciones en el affidavit de causa probable son bastante serias y graves.
I respectfully remind the court that they are merely allegations.
Respetuosamente les recuerdo a su señoría que son meramente alegaciones.
I respectfully suggest that the recommendation from the state is excessive.
Respetuosamente le comento que lo que ha pedido el Estado es excesivo.
I believe that a $5,000 bond would be more appropriate and certainly within the financial means of the defendant to post a bond.
$5,000 de fianza es más apropiado y ciertamente dentro de los medios financieros del acusado.
And with all due respect to the court, I respectfully remind the court
Y con todo el respeto merecido del tribunal, les recuerdo al tribunal
that it is not the intention or the purpose of pretrial incarceration to punish the defendant
Que el-
before trial.
no es la intención ni el propósito de encarcelar el acusado antes de juicio.
And again, I respectfully remind the court that he has a separate and independent residence,
Y de nuevo les recuerdo respetuosamente al tribunal que tiene él una residencia separada y aparte.
and there are less restrictive alternatives than holding him in custody with a $100,000 bond.
y que hay mucho menos, unas opciones menos restrictivas que detener al acusado con una fianza de $100,000.
All right, as you stated, the allegations, in this probable cause affidavit are serious allegations.
Las alegaciones contenidas en la affidavit de causa probable sí son alegaciones graves.
The alleged victim in this case, apparently these incidences started at the age of 10
Los instantes comenzaron a la edad de 10 años
and have been going on for approximately 3 years.
y han estado sucediendo por aproximadamente 3 años.
Allegations being that the most recent incident was December 23rd, 2019.
Y las alegaciones indican que el incidente más recién fue el 23 de diciembre de 2019.
Or, sorry, December 23rd was one incident, then there was another incident on December 30th.
Perdón, hubo un incidente el 23 de diciembre y luego hubo otro incidente el 30 de diciembre.
While this court does not find proof evident presumption great based on the probable cause affidavit,
Este tribunal no encuentra que ha habido pruebas evidentes ni presunción grande basado en el affidavit.
the consideration for setting bond is more than the defendant's ability to afford a bond.
Considerando que la habilidad del acusado para prestar la fianza es
Many more
más.
considerations that the court has to take, other things that the court has to take into consideration.
Así el tribunal tiene que tomar en su consideración otras cosas también.
And so based on these allegations this morning,
Así que basado en las alegaciones esta mañana
and also taking note that these are first-degree felonies,
y tomando en cuenta que estos son delitos graves en el primer grado,
I am going to impose $50,000 bond on charges 1 through 3.
impongo $50,000 de fianza en cargos 1 a 3.
Act,
Estoy ordenando que no tenga ningún contacto con la víctima,
no contact with any minors,
no puede tener contacto con ningún menor.
and if Mr. Morales posts his bond, he will be on a level 2 pretrial supervision.
Presta su fianza, si la paga, entonces estará bajo supervisión a nivel 2 previo a prisión.
Does the court happen to know which judge this case is being assigned to?
¿El tribunal sabrá a quién se le va a asignar este caso? No, no se sabe.
Okay, thank you. Thank you, Your Honor.
You're welcome. All right, Carlos Perez is the next person who needs a Spanish interpreter.
Mr. Perez is coming up right now, Judge. Page 19.
All right, Mr. Perez is before the court on one charge of grand theft.
El señor Pérez está delante del tribunal con un cargo de hurto mayor.
Number 2 is resisting officer without
El
violence.
número 2 es resistir a un oficial sin violencia.
Number 3 is violation of felony pretrial.
Y el número 3 es violar libertad de un delito grave previo a juicio.
He already has a no bond hold for that.
Sabe que tiene una detención sin fianza para eso.
And number 4
Número 4
is an immigration hold.
es una detención por inmigración.
That hold has been placed by Department of Homeland Security.
Esa detención la impuso el Departamento de Homeland Security.
All right, I find probable cause for these charges.
Encuentro que ha habido causa probable por estos cargos.
He has 2 no bond holds at this time.
Tiene 2 detenciones sin fianza en este momento.
The bond on charge number 1 is $1,000,
La fianza en el primer cargo es $1,000
and I'll leave that in place.
y lo dejaré así mismo.
Judge, we would just have 2 requests of the court. First, it would be a phone order, so he can use the phone to call his family.
2 peticiones. La primera es permiso
I'll
para
sign
usar
that order.
And the second was, Judge, when I was speaking with him briefly before court, he was a little confused about count 3. Could we just have the date of the alleged incident?
Hablé con él y está confundido acerca del cargo número 3. Si se pudiera aclarar.
Count 3 is a violation of pretrial.
El 3
Yeah, he
es una
didn't
violación
seem
de
to
previo
know what the
juicio,
case was about.
pero no sabe de qué se trata ese caso.
So Judge Allspector signed a warrant on December 10th.
La jueza Spector firmó la orden de captura el día 10 de diciembre.
It's case number 19-007-099 CF10A.
El caso 19-000-7099-CF10A,
where the charge is aggravated battery with a deadly weapon.
donde el cargo es agresión con agravantes con un arma mortífera.
Is that a filed case?
Es un caso que ya se tramitó.
Obviously it is. I don't know. I
I
don't,
don't know.
Obviamente lo es.
Yes, it is.
Mr. Payette?
His calendar called January 9th in front of Judge Osvaldo.
I'm sorry, State, can you repeat, please?
It is a filed case. He has calendar called January 9th in
Está en
front
la
of
lista
Judge
de causas el día
Osvaldo.
9 de enero ante la juez Alspector.
Very good, thank you.
all right, unless, Mr. Orozco's paperwork is attached to somewhere else, I don't have it. And I don't remember reading a probable cause affidavit about a battery on a person over 65, so I don't have that paperwork. On Orozco Novoa, I'm trying to find the paperwork, sir. I'm saying that I don't have it. So, if someone wants to give me the probable cause affidavit, and then, I don't know, Madam Clerk, if you have, blank determination forms, or if you can fill one out. Sure, thanks. Because I've looked again, I don't have it. It must be attached to something. Madam Clerk, on any of the paperwork that I gave you before? It's not? Okay. And now that I see it, I know that I did read it, but I don't see the paperwork. No, yes, it's attached to, I got it, thank you. It was attached to something. Thank you. Okay, all right. Etilvia Orozco Novoa,
Yes.
she is where?
Broward? Oh.
All right, Miss Orozco Novoa is before the court
La señora Orozco Novoa está delante del tribunal.
on one charge of battery on a person 65 years of age or older.
Un cargo de violencia sobre una persona que tenga 65 años o más.
I find probable cause for this charge.
Y encuentro que ha habido causa probable por este cargo.
All right, State,
¿Puedo hablar? I'm talking for me.
Ma'am,
It's okay.
ma'am, if you'll hold on a moment, I'm waiting for a response from the state attorney's office.
Judge, there are, sorry, Judge, there are no known priors. The state is asking for no victim contact and a $2,000 bond based on the allegations in the probable
No
cause
haya
affidavit.
contacto con la víctima y una fianza de $2,000 basado en las alegaciones.
Morning, folks. I'm well. You heard the request for the, bond. Is that something that you can afford? Oh, answer my question. Can you afford the $2,000 bond?
I try my best.
Okay.
And as I'm sure the court is aware from reviewing the probable cause affidavit,
Estoy seguro que el tribunal ya ha revisado la affidavit de la causa probable.
the victim in the case stated
La víctima, en este caso, dijo
that he did not wish to pursue any charges,
que él no quería seguir adelante con los cargos,
did not provide a sworn statement,
tampoco nos entregó una declaración jurada,
and did not allow any pictures of his injuries to be taken.
tampoco permitió que le tomaran fotos de ninguna lesión.
Based on the lack of priors,
Basado en el hecho de la falta que no hay antecedentes,
I am going to impose a $1,000 bond.
voy a imponer una fianza de $1,000.
No victim contact.
No puede tener contacto con la víctima.
No victim contact means no phone calls,
No tener contacto con la víctima significa no puede haber llamadas,
no text
no
messages,
puede haber mensajes de textos,
no social media,
no puede haber contacto por medios sociales,
no third-party contact.
ni por medio de una tercera parte.
And that no contact order is in
Y
place
esa orden de no poder tener contacto
until a judge lifts that order.
está vigente hasta que la elimine un juez.
The parties cannot decide on their own that they want to be together.
Así que las partes no pueden
As that
decidir
will
por
be
su
a
cuenta que
violation
quieren
of the no
unirse porque eso
contact
sería
order.
una violación de esta orden.
Do you understand that, Ms. Novoa?
Señora Novoa, ¿usted comprende esto?
I'm sorry, I'm talking the person, okay? The lawyer.
Mami, can I speak to her in Spanish? She translate. Oye, escúchame, cálmate. Yo te
Listen
voy a-
to me, calm
Yo
down.
te voy a sacar en un ratito.
I'm going to get you out in a little
Y
while,
después yo te explico lo que está pasando.
and then I can
Ella
explain what's happening later on.
Escúchame, solamente ella quiere saber si comprendiste con todo lo que hiciste, por favor.
She just wants to know if you understood everything that you did,
Y yo te voy a sacar.
and I'm going to get you out.
Lo único que ella necesita escuchar es que tú entendiste y yo te voy a sacar ahora. No
The
lo
only-
compliques más.
The only thing she needs to know is if you understood. Don't complicate
No me
things.
puedo quedar callada,
Por favor,
porque él
mami.
también me
Please,
golpeó.
Mom. Well, he
Por
beat me
favor.
up.
Okay, ma'am,
favor.
sir, stop talking now. Okay? All right. Ma'am,
Mire, señora,
this is what I'm saying to you now.
esto es lo que le estoy diciendo ahora.
Today's not your trial,
Hoy no es el día de su juicio.
or it is not at the investigative stage of your case.
Tampoco estamos en la etapa de investigar su caso.
If you have a defense,
Si usted tiene una defensa,
you will be able to speak with your attorney
usted va a poder hablar con su abogado
for that to be presented.
para que eso se presente.
Today is not the time for that.
Hoy no es el momento para eso.
What I need you to
Lo
understand,
que yo necesito que usted comprenda,
and I need you to check your attitude right now,
que ahora que cambie esa actitud que tiene ahora mismo,
is that you cannot have any contact with this
es
person.
que usted no puede tener contacto con esta persona.
And based on your response, I'm further going to say
Y basado en su respuesta,
that
voy a
I'm
decir
imposed,
además
that you cannot come within 500 feet of this
que
person.
no se puede acercar más de 500
That is
pies
going
de
to
esa
be in the
persona.
order.
Eso va a estar en la orden.
Cállate. Cállate.
Be quiet, be quiet.
That sounds like a good plan. You got it.
All right?
Cheche.
Okay, folks.
Your case is on page 7, Porter Muller.
Okay.
¿Sí?
Yes, folks. That's it.
Ok. Ahora te saco.
All right, on page 13, Jairo Oporta Muller.
It's page 7, Judge.
Oh, somebody wrote page,
Oh, he is on page 13, but he's also on page 7.
really? Okay. All right, Mr. Oporta Muller is before the court
El señor Oporta Muller está delante del tribunal
on one charge of touch or strike, battery, domestic violence.
con un cargo de tocar o golpear, agresión y violencia doméstica.
I find probable cause.
Causa probable.
Honor, the defendant has no known priors. Based on that fact, the sale will request $1,000 bond based on the alleged facts.
El acusado no tiene antecedentes y basado en eso pido que haya $1,000 de fianza.
$1,000 bond based on the alleged facts.
Y eso es basado en el acto alegado.
All right, who do we have here? Is this the alleged victim?
Yes, Your Honor.
Sí.
And ma'am, is there something you wanted to say?
Señora, ¿hay algo que usted quería decir? decir?
No, please answer the question.
Dígame sí o no.
Is there something you wanted to say?
¿Hay algo que usted quiere decir? Yes.
All right, so you need to understand
Ok, usted tiene que comprender
that everything you say today
que todo lo que usted diga hoy
is also being recorded
también se está grabando
and can be used against you at a later time.
y se puede usar en su contra más adelante.
Knowing that,
Sabiendo eso,
do you still wish to speak on the record?
aún así usted quiere hablar en el acta. Yes.
Okay, then I'm going to ask you to raise your right hand.
Entonces voy a pedirle que levante su mano derecha.
Do you swear or affirm to tell the truth?
¿Usted jura o afirma decir la verdad? Sí. Yes.
Okay, you can put your hand down
Okay, puede bajar la mano.
and please state your name for the record.
Por favor, diga su nombre para que conste en el acta. Mirta Zamora Tera.
You-
Taylor. Acérquese.
If you can come a little bit closer to, yeah, okay,
I'm sorry.
all right. No, I was saying if she can come a little bit closer to the microphone.
I said too. Yeah, okay.
What is it that you wish to say?
¿Qué es lo que usted desea decir?
Yo quiero quitarle el cargo.
I want to remove the charges.
Judge, we can't hear, I'm sorry.
I want to remove the charges
Porque él es el que
You need to talk in the microphone.
Habla en el
él
micrófono.
es el que provee todo la parte financiera de la casa y tenemos
because
cuatro
he is the
Can't
one
hear,
that
I'm sorry.
provides because he is the one that provides all the financial side to my home. Acérquese al micrófono.
y tenemos 4 niños.
And we have 4 children.
Whether charges are filed is in the hands of the state attorney. Not,
Si se presentan, se formulan cargos o no, está en manos del abogado del Estado.
based on the allegations this morning,
Basado en las alegaciones esta mañana,
does Mr. Mueller have any priors?
¿Señor Mueller tiene antecedentes?
Okay,
No hay antecedentes, no.
all right, I will,
I'm sorry, did the state say that he had no priors?
yes, sir.
Judge, that's what he informed me as well, so we were gonna ask for release on non-monetary conditions, excuse me. On his own recognizance, ideally,
él como
especially in light of the
me ha
testimony
indicado
of the
lo
alleged
mismo.
victim.
Como no tiene antecedentes, según lo que él me explicó también, pedimos que lo dejen salir en libertad sin tener supervisión. Y según lo que
Or in the
dijo,
alternative to pretrial release,
o en la alternativa, servicios previo a juicio.
he's advised he does have another place he can stay if there is going to be a.
Not have
No
a place?
comment.
I'm sorry, I didn't understand. Did you say he does not have a place?
Sure, he does.
Él ha
He says he can
indicado,
stay with his sister-in-law.
él ha dicho que él si tiene donde quedarse, se puede quedar con su hermana, se lo dejarán salir en libertad.
All right, based on the allegations, I am going to impose a $1,000 bond,
Basado en las alegaciones, voy a imponerle $1,000 de fianza
and I am going to order no victim contact until further order of the court.
y voy a ordenar que no haya contacto con la víctima hasta que haya otra orden más adelante de algún tribunal.
No victim contact means no phone calls,
No tener contacto con la víctima significa no puede haber
text
llamadas,
messages.
mensajes de textos,
no social media,
ni por medios sociales,
no third-party contact.
ni contacto por medio de una tercera parte.
Okay? All right. Does anyone else need a Spanish interpreter? All right, thank you very much. Happy New Year.
Happy New Year.
All right, we have one more on the sign-in, Lael Farias on page 11.
He's coming up, Your Honor. proceed.
All right, Mr. Farias is before the court on one charge of resisting officer without violence. Number 2 is domestic battery by strangulation, and number 3 is battery causing bodily harm. And I find probable cause for these charges. Okay, all right, I'll hear from the state. Ma'am, are you the alleged victim in the case?
Yes.
And do you wish to speak on the record?
Yes.
And do you understand that everything in this courtroom is being recorded and can be used against you at a later time?
Yes.
All right, then I'm going to ask you to raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Please state your name for the record, if you can come a little closer to the microphone.
Melissa Rivera.
Okay, and what is it that you wish to say, Ms. Rivera?
I just want to state that I will not be going through with these charges, and I ask if you can possibly give him the lowest bond because we just moved up here from Chicago. He is the provider. I don't have much means to any funds.
She does have a pending domestic in Polk County. Other than that, I'm not seeing any priors.
Judge, I'm sorry, we can't hear the state.
Can you hear me now?
Yes, ma'am, thank you.
Okay. I was saying that the defendant has a pending domestic case in Polk County. Other than that, I'm not seeing any priors.
Do you
Your
know?
Honor, he does have other priors out of Illinois. He has a domestic violence battery in 2016. A domestic violence battery.
Know if either the pending matter or the prior matter involve this alleged victim?
It does not, I can't tell. But it's out of Illinois, Your Honor.
Okay. All right. Mr.
Judge,
Glover?
from what, I'm sorry, I can't tell if someone's speaking now. We're having a real hard time with the audio today.
Well, I don't know how to
We
fix.
can hear you, yeah.
I
we
don't
can
know
hear
how
you.
to fix it, and I've
Yeah.
asked the attorneys to speak in the record. But I'll let you know that I've been told that he has a pending domestic matter in Polk County, that he has a prior a prior matter from 2016 in Illinois. That's what has been said.
Thank you, Judge. I just didn't want to speak over anyone. We can hear the court pretty well, but the other two microphones we're having a hard time with.
Okay.
Judge, just from what he's told me, he works as a driver. He works for America's Movers is the name of the company. $11 an hour is what he's doing. He says he can afford about $200 total. He does not live with the alleged victim on counts 2 and 3. I believe that's the individual in the courtroom there. Family-wise, he's got his aunt in the community, his grandmother as well, and he's lived down here for about a year and a half.
All right, the allegations that I have before me, that I think there's a not in custody capias from an incident in August 2nd of this year. That's the basis for the domestic battery by strangulation. And in that probable cause affidavit, it says that, Mr. Ferris struck Lael in her face with the back of his open hand. She pushed him to defend herself. And that during the struggle, he used one of his hands, wrapped it around her throat. She felt his fingers pressing down against her trachea area, causing her to lose breath and the inability to speak. She then began to kick and pull away, making several attempts to grasp for air. During the altercation, one of the daughters caught a glimpse of the physical altercation and began banging frantically on the sliding glass door that led to the back patio. And this is what caused Farias, it enabled her to quickly run into the home and lock herself in the bathroom. That's an incident from August 2nd. This current incident, January 1st, that the officers reported to the home that they refused to answer the door. The officer was able to observe the female through the window as well and attempted to speak with her regarding the incident. She would not answer the front door for police and was only providing short answers. While trying to speak to her, Lael began to dominate the conversation and spoke over her, not allowing her to finish speaking. So, based on what I've heard this morning, I find probable cause, and I am going to impose bonds. The $100 bond. So I will leave that in place. Number 2, I am going to impose a $10,000 bond. And on number 3, $1,000 bond.
I'm sorry, Judge, what was count 3?
1,000. No
Thank you, Your Honor.
no victim contact. I'm ordering no victim contact. That means no phone calls, no text messages, no social media, no third-party contact until further order of the court. This order can only be lifted by a judge. Do you understand that, Mr. Farias?
Excuse me, I didn't hear that. I was talking to my public defender.
Well, I think you need to listen to me. I said no victim contact.
Yes, ma'am.
Okay, and that means no phone calls, no text messages, no social media, no third-party contact until that order is lifted by a judge. Do you understand that, sir?
Yes, ma'am.
Okay. All right, thank you, folks. Anna Groves.
Good morning, Happy New Year.
Okay, I'll deal with that when at the end. Ms. Groves is before the court this morning on one charge of touch or strike battery. It's domestic violence. I find probable cause.
Ms. Groves has no Florida priors. Based on the facts of the case, the state will be requesting $1,000 bond.
Okay.
Judge, we're fine with the $1,000 bond. The only thing we would ask would be a photo order for her.
All right, I'll sign the photo order, $1,000 bond, no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Ms. Groves?
Yes, ma'am.
Okay. All right, Jennifer Cespedes.
Joe.
Good morning. Ms. Cespedes is before the court. Charge 1 is touch or strike battery. It's domestic violence. Number 2 is an out-of-county felony hold. Out of Miami-Dade with a no, that's a no bond hold and is not for magistrate. I find probable cause. And, I'll impose a $1,000 bond on charge number 1. No victim contact.
Thank you, Judge. The only thing we would ask is for a photo order for her.
Okay. All right, Michelle Cooper.
Hello,
Ms. Cooper is before the court on a charge of touch or strike battery. I find probable cause. She has $1,000 bond. No victim contact. No victim contact, Ms. Cooper, means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am.
All right.
Judge, Miss Cooper was in First Step Behavioral House prior to this incident, and I've spoken with the personnel over there. They're currently trying to find another rehabilitation center for her to go to. But they have not been able to do that yet. They indicated to me they're working on that this morning. I was wondering if we could put Miss Cooper on this afternoon's docket to see if they've made any progress, and maybe if they have a place for her to go, the court might consider allowing her to be released, to pretrial release, to go to a residential treatment facility.
Let's do it this way. If they call you and tell you they found a place, then you call my office and we'll put it on, whether it's today or tomorrow.
Okay, very good, Judge.
Okay?
I spoke with Dave over there, Miss Cooper.
Okay.
Okay, so we're trying to find you a place to go.
Okay, so I won't have to pay the bond if I find a place?
If they find a place and the judge says it's okay, yes.
Okay.
All right, Mr. Shade, on page 13, has DeLawrence Orr. Is being released. Okay. Mr. Orr bonded Mr. Shade.
That's okay.
I find probable cause. And then Terrence Harris.
Main jail, he's coming up, Your Honor.
Okay.
He's on page 13 as well.
On page 13. All right, Mr. Harris is before the court on a KPS on a municipal ordinance matter. It's for panhandling, and I find probable cause.
It's a time for the lawful judge.
Everything okay? Okay. Well, the main jail keeps saying that they can't hear from the state side. I don't know if it's the microphone.
Is it just the state attorney, or is it?
No, it's just the, it's
Just
just,
them?
yes.
Okay, I'll check on that.
Okay.
All right.
All right, so Mr. Harris, what does Mr. Harris wish to do today?
There's gonna be a time served offer, Judge.
Mr. Harris, the city's
Yes.
offering you time served to resolve your case. Do you wish to accept that?
Yes.
All right, sir, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And, Mr. Harris, you understand the offer that has been extended to resolve your case?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
For mental.
Is there anything about that today that would prevent you from making a decision?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served. I'll give you 6 months to pay your court costs.
Thank you.
Judge, I also have Sean Johnson, who's on page 20.
Yeah?
Correct, he's in Maine.
He's your client?
He is, Judge.
Okay. All right, do we have Sean Johnson on page 20?
Judge, they're gonna get him out of the bag.
Okay.
He's here? Judge, it'll be just a moment.
All right. Latavia Bertrand. Good morning, Ms. Bertrand. You are before the court this morning on one charge of aggravated battery causing bodily harm. Number 2 is battery causing bodily harm.
Yes, ma'am, I understand that.
And I find probable cause for these charges.
Okay, ma'am, is there any way you
Judge,
can give me?
Miss Bertrand is not in a position to post any monetary bond for herself, Judge. She has been a lifelong resident of Florida. She's been living in the same location by herself for the last 4 months. She has a job doing events, and she has a 3-year-old child. She's a student at Atlantic Tech, studying for her GED. And I would ask Judge to consider pretrial release for Miss Bertrand.
State?
Your Honor, the defendant has a number of priors, most of them misdemeanors, but there is a possession of cocaine, a violation of an injunction. In 2012, there was a battery and a grand theft in 2015. The state would be asking for a level 2 with a GPS monitor and no victim contact.
Right, I'll release Ms. Bertrand to pretrial supervision, level 2 pretrial, okay? So,
Thank you all.
Thank you, Judge.
ma'am, no victim contact. Do you understand that?
Yes, ma'am.
Okay. Okay. All right, Mr. Johnson is here, Mr. Sheep.
I
And,
understand that he's got a violation of probation, so he won't be released today.
right,
I just wanted to let Mr. Johnson know that I will see him in Judge Coleman's division when he is sent there.
looks like he has a status tomorrow.
Okay, so I'll see you tomorrow, Sean.
So, Mr. Johnson, just so you know, you're before the court for a grand theft charge, and then also there is the violation of felony probation. I find probable cause. You do have $1,000 bond on the grand theft charge. The VOP, however, is a no bond hold, and like I said, you have court tomorrow with your division judge at 8:30. Okay? All right, Sarah Richings.
No problem.
And Ms. Richings, you're before the court because you have 3 violation of pretrial. Those are warrants that are signed with no bond holds and are not from magistrate. Then there is a misdemeanor capias, and that capias was issued with a $500 bond. And I find probable cause and leave all those in place.
Judge, I was looking this case up in Odyssey, and it appears as though the state has entered a no information
On which one?
on counts 1, 2, and, counts 2 and 3, and I think count 1 they filed as a misdemeanor. Maybe we could get some verification of that.
Okay.
Well, I mean, if she's charged with a couple of misdemeanors, I think she'd probably be inclined to resolve those charges.
Yeah, well, if they don't have the information to verify it, and then this warrant was signed by her division judge, so they have to make the necessary changes so that everybody's on the same page. If that can be verified, again, if this is like the other matter, and if she does want to resolve the cases, she can be reset on the docket.
Well, my Odyssey is not down, and I'm looking at the no information right now, signed on December 9th. Count 1 was a reduction of a charge to driving on a suspended license. Count 2, the grand theft auto, was no infoed. Count 3, the possession of heroin was no infoed, which, from what I'm seeing here, I mean, this is a situation where Miss Richings could possibly resolve these matters and be released from jail if the court felt that time served or something along those lines was appropriate. Okay, so the violation, count 1, the misdemeanor is a violation of her pretrial release conditions. Okay. Okay. Yeah, I know I had some problems with it myself.
All right, folks, so we know she has to go before the division judge on that matter, okay?
You have to go before Judge Tobin Singer, Miss Richings, but I think things are ultimately going to work out for you.
All right.
When is the court date?
Christina Rossi.
Don't have one yet.
All right, Ms. Rossi's before the court. Charge 1 is grand theft, and 2 and 3 are violation of pretrial. Those are not for magistrate. I find probable cause, and she has a $1,000 bond on 1.
Ms. Higgins?
Cassandra Higgins.
She's here?
Ms. Higgins is before the court on 3 charges of aggravated assault with a deadly weapon without intent to kill. I find probable cause. Does Ms. Higgins have any priors?
None that I can see, Judge.
Okay. Does the state wish to be heard?
The state is asking for 1,500 on count 1, count 2, and count 3, and no victim contact.
Okay.
Judge, Ms. Higgins lived here her whole life, all 27 years. She lives in Hollywood with her father. In addition to her father, her mom is here, her sister is here. She's right now going through a divorce. She is working for a catering company making $11 an hour, and so hopefully her parents can help her post a bond. So we'd ask for the lowest reasonable bond for her.
And as the court's aware from reading the probable cause affidavit, she did surrender herself.
Okay. All right. I believe the $1,500 on each count is reasonable. I'll leave those in place. No victim contact. Okay. Jeremy Ragunadan.
He's coming up, Your Honor.
Mr. Ragunadan, good morning, is before the court on 2 charges of touch or strike battery. It's domestic violence. I find probable cause. I'll hear from the state.
Your Honor, as to count 1, the state would be requesting $1,000 for count 1 and 2.
You're going to be asking for pretrial release for him. He's lived here for the last 18 years. He will stay with his sister or a friend in Miramar. He works as a mason, and he doesn't believe he can afford bond, so he's asking for pretrial release.
And I don't have nobody else.
Based on the allegations, I am going to impose a $1,000 bond on each charge. and no victim contact until further order of the court. Ladaria Smith.
Here he is.
All right, Mr. Smith is before the court. Charge 1 is battery causing bodily harm, domestic. Number 2 is resisting officer without violence. And I find probable cause.
Your Honor, for count 1, the state will be requesting a $2,500 bond. And based on the facts on the case and based on his prior history. And it's for count 2.
Nothing from the defense, Your Honor.
Oh, in addition, no victim contact, Your Honor. For count 2, the state would be requesting a $100 bond.
All right, 2,500 on charge 1, no victim contact. And that means no phone calls, no text messages, no social media, no third-party contact, okay? All right, yes? Oh, Anthony Roman,
Judge, he's coming up right now. We're gonna need a photo order for him, please.
okay? Mr. Roman is before the court, 1 charge of touch or strike battery. This is also domestic violence. I find probable cause. Okay? Yes. Oh. It's every new year that happens. All right, Mr. Goldberg, if you want to go ahead while we're waiting for the state.
From what Mr. Roman's told me, he does not live with the alleged victim. He's lived here for the last 12 years. He lives in Hollywood with his sister and her children. He's actually supposed to start this afternoon at a warehouse. He's got an appointment later this afternoon. So, in addition to the photo order, Your Honor, we'd ask the court to set a financial bond for him of no more than $250, as that's all he can afford. Or pretrial release, Your Honor.
Your Honor, the state would be requesting a $1,000 bond with no victim contact.
All right, based on the allegations, I'll grant LRR to pretrial supervision, and no victim contact is also going to be in place. Mr. Roman, no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am, I do.
And also, as to the pretrial supervision, you need to report no later than tomorrow morning. If you don't show up, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am. Happy New Year's.
Same to you, sir. All right, Jesse Walker.
We're ready, Your Honor.
Good morning, Mr. Walker is before the court from 1 charge of touch or strike battery. It's domestic violence. I find probable cause. Right, Mr. Goldberg? 15 on,
First, we'd ask for, I know the court's gonna, enter an order of no victim contact. He's asking for an order allowing him to return one time, with law enforcement so that way he can retrieve some personal property. He's going to stay with a family friend. He's lived here in South Florida since 1995. He has his sister here, his brother, his mom. He works for a tire shop. He's been working there for about a year, and he makes about $400 a week. So there's not much financially that he'll be able to afford.
all right, 15, $1,500 bond and no victim contact, okay?
Thank you.
Thank you, Judge. Could he have that order so he could go one time with
And
law enforcement?
one time with law enforcement, sir, that means you cannot go there unless you've contacted law enforcement and they go with you to the location. Do you
Yes, ma'am.
understand?
Yes, ma'am.
Thank you, Your Honor. Mr.
Okay.
Levinsky, come on up.
Good morning.
All right, Jaroslaw Urbanski.
Yes.
Mr. Urbanski is before the court on one charge of battery causing bodily harm. It's domestic violence. I find probable cause.
The defendant has a 2014 DUI, for which he was adjudicated guilty. That's the extent of his Florida priors, but given the facts of the case, Your Honor, the state will be requesting a $2,000 bond.
Okay.
Judge, that's fine with us. The only two requests we have is number one, a photo order for him, and number two, same thing as Mr. Walker. He'd ask for an order for one time allowing him to return so he can retrieve some property.
All my property, actually, because I didn't.
With law enforcement. Yep.
All right, $2,000 bond, no victim contact, and defendant is allowed one time to go to the residence with law enforcement to pick up his property, okay? Keon Lamar.
Mr. Lamar is present, Your Honor.
How you doing, Your Honor?
I'm well, sir. Mr. Lamar is before the court this morning on one charge of touch or strike battery. It's domestic violence. And I find probable cause.
Your Honor, the state will be asking for a $3,000 bond based on the facts of the case and based on the fact that Mr. Lamar does have a criminal history that includes a resisting officer without violence, that adjudication withheld in 2018, 2015, aggravated assault with deadly weapon and battery that was dropped, 2013 battery on a person over 65 in which he pled no contest, adjudication withheld, 2012 burglary, adjudication withheld, possession of burglary tools, adjudication withheld, resisting officer without violence, adjudication withheld.
Okay?
Judge, we were gonna ask for $1,000, so it'd be $100 through a bondsman. He doesn't live with the alleged victim. He's lived here in South Florida his whole life. He lives in Hollandale with his mom and his brother. He's not working, but additionally has his grandma and his aunties here. Judge, he'd also ask for a photo order. He's got some injuries.
All right, based on the allegations that I have before me, that's apparently this incident occurred because the alleged victim told him that she did not want to be with him anymore, that there's allegations that he followed her, he punched her in the face, causing her to fall. She got up, walked over to an efficiency to call 911, where he followed her, grabbed her by the hair, pulled her to the ground. his mother came asking for his stuff. She told him that there was nothing else in the home that belonged to him, at which point he pushed her out of the way, entered the home, broke the television in the living room, and then proceeded to walk outside and break several windows outside of the home by smashing them with a chair, causing them to shatter. Based on the allegations, I am going to impose a $5,000 bond. I am going to order no victim contact, and I am going to order Mr. Lamar that he cannot come within 500 feet of the alleged victim. All right, Clifton Robinson.
Present.
And Mr. Robinson is before the court for a touch or strike battery charge. It's also domestic violence, for which I find probable cause.
The state will be requesting a $2,000 bond, given the facts of the PC. Also, the defendant has a pending DUI, a battery that the state declined to adjudicate, however, it involves the same victim. 2007 cocaine possession that was abandoned, resisting officer without violence, adjudicated guilty. And he does have a 2006 aggravated assault that was dropped as well.
Mr. Goldberg?
I'm sorry, what did the state ask for?
$2,000.
Say again, please?
$2,000.
Judge, we're going to ask for pretrial release. He does not live with the alleged victim. He's lived here his whole life. Here in Fort Lauderdale with his mom and his two children. He drives a forklift for Eastland Food Company. He's had that job for the last 10 years. And so he wants to make sure he can get out and get back to that. He doesn't want to lose his job.
All right. Based on the allegations, I am going to impose a $3,000 bond. No victim contact. That means no phone calls, no text messages, no social media, no third-party contact. There's allegations that there's been violence before with the same victim. All right, Christopher Vitti. Mr. Vitti's still on medical loan? And I thought so. So this does not need to be reset. I already found probable cause 2 days ago. Okay? All right. Dominic Leveridi.
Main jail, Your Honor.
Okay. All right, sir, you're before the court on one charge of aggravated assault with intent to commit a felony. It's domestic violence. Number two is carrying a concealed weapon or firearm. And number three is possession of cannabis 20 grams or less. I find probable cause for these charges.
I just don't know how this is a domestic violence case, Judge. I'm not saying there isn't probable cause for an aggravated assault, but it doesn't look like it's a domestic case.
No, that's right. It's not a domestic case. This is with the bartender at Ale House. So it's aggravated assault with the, not domestic, okay? All right. I'll hear from the parties.
Judge, I'm not seeing any known priors. I have been made aware that the victim has safety concerns. And based on the allegations, the state would be asking for $1,500 on count one, 100 on count 2, 100 on count 3, no victim contact, and no return to the bar, and surrender of any firearms and ammunition.
All right, Mr. Goldberg,
I'm sorry, Judge, the state asked for 1,500 on count 1?
they did.
I think 1,000. And then 1,000 for counts 2 and 3?
No, I think they said 100 on 2 and 3. Is that correct?
Yes,
Right.
Your Honor.
Give me just one moment, Your Honor.
Let me tell you, I am gonna go higher with the bond than $1,500. So before you have that conversation with him, I'm not gonna let you know that.
Okay, Judge. Well, we were gonna ask the court for $150, which would be the 15 on count 1. He does not live with the alleged victim, from what he's told me. He's lived here in South Florida for 10 years. He lives with his mom in Coral Springs. His mom has got some health issues. She's dealing with breast cancer, and he's really taking care of her. He works in a warehouse for Broward Motorsports. He's the only one that's working in the house. He's had that job for over a year. In addition to his mom, he has some sisters and brothers in the area. And from what he told me, the most he can afford is $150. So we were going to ask the court to leave the $1,500 on count 1.
All right, so the allegations that I have before me is that while at Ale House, Mr. Levarity got into a verbal argument with the bartender after being asked multiple times to stop revving the engine of his motorcycle, which ultimately disturbed fellow patrons. He then jumped over the metal fence, entering the partially enclosed outdoor patio bar, and aggressively ran towards the bartender. And he was overheard by another employee saying that I have a effing gun, I'll shoot all of you, while lifting his shirt, exposing the butt of the firearm, which was located within his waistband. Multiple witnesses advised that he was heard making the statements such as, "The next person that touches me, I'm gonna pop. And I don't care if anybody touched me, I'll shoot the next person who touches me." They were able to get him outside to the front door. Once outside, he bumped into another victim who put up his hand in an attempt to prevent him from striking him. Upon that victim's hand making contact with the defendant, he then turned towards him, grabbing onto his firearm located within his waistband. They advised that he removed the firearm from his waistband and proceeded to raise the firearm while pointing it at the alleged victim, who said he was in fear for his life. Somebody was able to kick the firearm out of his hand and tackled him, holding him down until police arrived. That gun had a magazine containing 4 live rounds of a 9mm ammunition. So those are the allegations that I have before me this morning. I am going to impose a $7,500 bond on charge number 1. No victim contact, no return to that location. If he has any guns or firearms, they must be surrendered prior to his release. Dorian Yepes.
I've been advised he has private attorney Chad Mason. Is that right? Yeah, I'm still going to pursue this. Go ahead.
Mr. Yepes, when did you hire Mr. Mason?
I spoke to him over the phone yesterday, but no paperwork or anything has been signed.
So let me ask you this. Did you guys come to an agreement that he's representing you?
he told me just to come here and I guess because there's some things that are indicated without a bond, so he said to come here and speak with you. So I may have the bond and then we will meet after I get out.
So as we're speaking, you have not hired Mr. Mason, is that correct?
Correct. I haven't signed nothing yet.
Okay, okay. All right, I just want to be clear that you haven't already hired him for this matter. Just, I know you're saying that you spoke with him, but if you did not come to an agreement with the attorney, if you didn't sign any paperwork, he's just told you to come and deal with whatever happens today. Is that correct?
Correct.
All right. So you are before the court today, and also I need to just let you know that you are entitled to counsel. If you wish to use the public defender's office or sign up for the public defender's office, that is also available to you. Or you may continue to represent yourself here today and then later on to speak with your private counsel. Do you understand all of that?
I do. Is it possible I could still speak with?
Sure, I'll recall your case after you've spoken to the attorneys over there. All right, Devin Alexander,
sorry,
yes, yes.
I admit I was talking to somebody else. Have we been appointed on the case? I didn't. I didn't see what.
He hasn't hired Mr. Mason for this arrest. It's just that, and he's saying that the attorney told him to come to first appearance and then when he's out to speak with him. So he doesn't have counsel. So if he wants to speak with the public defender's office, I'm giving him that opportunity.
Sure. Okay.
Okay?
Proceed with what we spoke about. Judge, I've already spoken with him before. I learned
Okay.
that I can represent him on this proceeding.
All right, so Mr. Yepes is before the court. Charges 1 and 2 are battery on an officer or firefighter. Number 3 is a violation of an injunction. Number 4, disorderly intoxication in a public place. Number 5, 6, 7, 5 and 6, resisting officer without violence. 7 and 8, resisting officer with violence. All right, I find probable cause for these charges. State?
Yes, Judge, it looks like he has a pending case in Miami. It's an aggravated battery and 2 counts of misdemeanor battery. I'm not seeing any priors. Based on the allegations, the state is asking for $3,000 on count 1, count 2, count 3, $500, and then count 7 and 8, we're asking for $1,000 each.
Judge, we would ask initially for a photo order for Mr. Yepes. He does have some injuries here. He makes $11 an hour. He's in a training program right now at Sixt Rental Cars to be a manager. He lives in Miami. He's lived there for the last 5 years. He lives by himself. He has no family in the area. And so he said the most that he thought he could afford was $500 to post bond.
So I have just a question. That violation of the injunction charge? What facts support that? I'm going back on what I said, because I had a note about that, unless I missed it somewhere. No, never mind. I see it. Okay. All right. So, I'm sorry. What did you say, Mr. Goldberg?
Sure, Judge. Just that we would need we were asking the court for a photo order for Mr. Yepes. He does have some injuries. He's told me he makes $11 an hour. He's in a training program for Sixt Rental Cars, He's lived for the last 5 years in Miami. He lives by himself. He doesn't have any family in the area. He told me that the most he thinks that he can afford is $500 total bond, and so he would not be financially able to post what the state is seeking.
Okay. All right, a $3,000 bond on charge number one. $1,000 on 2 and 3. $1,000 on 7 and 8. There's a no contact order in place, and for which Mr. Yepes is before the court today for that violation. And sir, just so you know, that order is still in place. No contact. Okay. Devin Alexander. Mr. Alexander is before the court on one charge of touch or strike battery, it's domestic violence. Number 2 is tampering in a misdemeanor proceeding, and I find probable cause.
So many priors.
Okay,
I'm asking for $1,000 bond on count 1, $1,500 on count 2, and no victim contact.
Judge, from what he's telling me, this is his first offense. He's not been in trouble before. He's telling me he's a single father. He's lived here in South Florida since 2016. He lives in Hollywood with his son and with his mother. He's an electrician as well, Judge. If this is his first offense, we'd ask for his release on his own recognizance, or in the alternative, that he be placed on pretrial supervision. He's real concerned about his child.
all right, I'm going to deny the pretrial release. You'll have a $1,000 bond on charges 1 and 2, and no victim contact. Christian DeVoe. Mr. DeVoe is before the court on one charge of battery, causing bodily harm, domestic violence. Number 2 is false imprisonment. And I find probable cause. All right, state.
Judge, I'm just seeing some misdemeanor trespass and driving priors. The state is asking for obviously no victim contact, $2,000 bond on count 2, and $1,000 on count 1.
State, can you repeat?
1,000 on 1, 2,000 on 2.
Judge, he's asking for pretrial release. He said he'll stay with his uncle in Pompano. He's not working right now. He's lived here for the last 2 years, and he's unable to afford the $3,000 that the state is seeking. In addition, Your Honor, we'd ask for a phone order so that way he can have access to his contacts.
I will sign the order. He'll have a $1,000 bond on 1 and 2,000 on 2, and no victim contact. Brian Payette.
He's coming up.
All right, Mr. Payette is before the court. Charge 1 is aggravated assault with a deadly weapon. It's domestic violence. Number 2 is touch or strike battery. It's domestic violence. I find probable cause.
He does have a 2005 battery, 2006 DUI, and he violated his probation. 2008 criminal mischief, there was a battery that was dropped.
Fayette advises me he's 60 years old. He's lived here in South Florida since he was 12. He's asking the court for the lowest bond possible. He's not working. He just receives disability and food stamps in the amount of $800 a month. So he's going to have a real hard time posting whatever the court sets.
And Judge, out of Connecticut, way back, he has assault on law enforcement and burglary convictions.
Okay. All right, I am going to impose a $2,500 bond on charge 1, $1,000 bond on 2, no victim contact, and that means, Mr. Payette, no phone calls, no text messages, no social media, no third-party contacts. Do you understand that, sir?
Yes, ma'am.
Okay. Sean Rich?
Judge, I'm sorry. Last thing, Mr. Paya, we would ask for an order allowing him one time to return to the property so he can retrieve some personal property with law enforcement.
I'm going to deny that, based on the allegations. All right, Sean Rich?
He refused, Judge.
Just to let the court know, we took a
Okay. All right, well, he still needs to be on these new charges. So let's reset him one more time and see what happens. Okay. Joshua Wainman? Yes, thank you. And Mr. Wainman is before the court on a KPS. Charge 1 is a misdemeanor KPS, and then 2 and 3 are civil writs. The KPS is from April 3rd of 2018 for a charge of driving a license suspended.
Mr. Wayman would like to resolve the misdemeanor, Judge.
Okay, so does the state have an offer for him on that? And did we look to see if he had any other, driving while license suspended charges?
Does Judge, in 2018, he also has a number of felony priors.
Do we have his driving record? Are those the driving records for today? I don't have Wayman's. I don't have his driving record.
I'm printing a copy. Your
Okay.
Honor.
Well, just tell me, so that he knows.
This would be his third strike, Judge.
This would be his first?
Third.
His third within what?
So he has one 2018. Okay, it's his second within 5 years. The last
Okay.
one's from 2015.
All right, Mr. Reed, do you want to talk to him about that?
This would be his second. You get one more, it's 10 days in jail, Mr. Wayman.
Understandable.
Okay, so you need to get your license straightened out. Don't drive until you get your license straightened out.
I'm not, sir.
All right. Also, you could be declared habitual offender and lose your license for an extended period of time.
I understand.
All right, so get that license straightened out.
Yes, sir.
All right. So, Mr. Wayman, if you wish to resolve this case today, I'll sentence you to time served. Do you wish to accept that?
Yes, Your Honor.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. And do you understand the offer that has been extended to you today to resolve your case?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you need any more time to speak with your attorney?
No, Your Honor.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter at this time, guilty or no contest?
No contest, Your
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication time served, okay?
Thank you, Your Honor.
And I guess your attorney probably already told you on those civil writs, you have a purge amount on one of $312, and the other one is $700, okay?
Yes, Your Honor. Thank you.
All right, Jamal Brissett. And Mr. Brissett is before the court on a DUI, alcohol or drugs. It's a second offense. I find probable cause. State?
Judge, he does have prior cannabis and prior possession of a handgun with altered serial number. I'm fine with $1,000 set in place, no alcohol, no intoxicants.
Okay. All right, $1,000 bond, no alcohol or intoxicants. All right, Jeffrey Wheaton.
Judge, Mr. Wheaton is a medical reset.
Mr. Wheaton,
Ricky.
medical reset. Ricky Bynum.
He's here, Judge. He'd like to resolve if possible.
All right, Mr. Bynum as a misdemeanor KPS. The charge is trespassing. State, do you have an offer for Mr. Bynum?
So withhold court costs and no return.
Okay, withhold, court costs, no return.
Judge, he'd like to accept that offer.
All right,
Thank you.
Mr. Bynum, please raise your right hand.
Will I be released today? Okay.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Bynum, do you understand the offer that has been extended to you to resolve your case?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
All right, ma'am. Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is a withhold adjudication court cost. No return to this location.
All right.
Oh.
Well, okay, what was the location?
Carl Pierce. What?
Do we have the location of that no return?
All right, state, you have the address. Is it 6801? 1601 North Federal Highway. Is that a business?
House or?
Okay. All right, Carl Pierce.
Come on up. Mr. Pierce is present. He's declined the public defender.
Oh. Instead it's that. But at the same token, I do need help with the situation. I did sign that. I wanted to clear my charge.
On recall for a moment, please?
Yes.
Lucas Macedo.
Judge, I think Mr. Pierce is ready to proceed. He's proceeding with the declining of the public defender. And Mr. Macedo is present, whichever case you would like to call.
Okay, well, all right, Mr. Macedo, you're before the court for a touch or strike battery,
No.
He's not that. Yes, you are. Yes.
and I find probable cause. State,
I'm not finding any priors, Judge.
okay. All right, Mr. Goldberg, anything you wish to say? He has $1,000 bond.
Judge, the only thing that we're asking is a photo order for him.
And no victim contact, and I'll sign that order.
Thank you, Your Honor. Mr. Pierce, why don't you come back up? The judge is gonna read your charges to you.
Okay.
Okay, Mr. Pierce, do you understand, sir, that you are entitled to counsel at this hearing?
Yes.
And are you refusing the services of the public defender's office this morning?
I wanted to hear my charges first so I can at least,
It doesn't,
some help.
it doesn't go that way, because I'm
I
not,
would like a
I'm not,
chest
sir, that's not how it works. And I think you've been sitting here all morning and you've seen everybody come up. You either are going to use the public defender's office or you're not. So what are you doing at this time?
Okay,
I am not going to tell you everything and then give you a chance to go back and talk for you to come back. That's not how it's gonna work. So, do you want to speak to the public defender's office right now before I tell you what's going on?
Yes.
All right.
Yes. Can I hear the charges and then,
I just told you I'm not gonna do that. Juan Torres.
Mr. Torres is up in North Broward.
Oh, okay.
Fuse, Judge.
All right, so we'll reset Mr. Torres. Thank you. Craig Hutchinson.
He has a private attorney, Judge, and I believe his bond has been posted.
Has Mr. Hutchinson's bond been posted? Okay, so Mr. Hutchinson, you are before the court. You have one charge of DUI, and then charges 2, 3, and 4 are DUI with damage to property or person. Number 5 is a traffic infraction, careless driving, not for magistrate. I find probable cause for these charges, and I've been told that your bond has been posted, okay? Waldemar Penaloza.
North Broward.
no, yeah.
All right, Mr. Penaloza is before the court. Charge 1 is DUI. 2, 3, and 4, DUI with damage to property or person of another. Number 5, careless driving. That's not for magistrate, and I find probable cause. Does anyone wish to be heard?
Yeah, yes, Judge. Mr. Panaloza has been a resident of South Florida since 1996, or 2090, yeah, 1996. He's worked as an auto mechanic since 93. I understand his last contact with the criminal justice system was some time ago. I don't believe he's going to be able to post much of a monetary bond. I was going to ask the court to consider pretrial release for him.
It's Mr. Penaloza to pretrial supervision. No alcohol or intoxicants.
Thank you, Judge. You have to report tomorrow morning. Make sure you get a map from the deputy up there.
All right, Mr. Penaloza, the deputy will give you the information for the pretrial office. You need to report by tomorrow morning. If you don't show up, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
And also, as a condition of your pretrial, I am going to order random testing, okay? And no alcohol or intoxicants. Do you understand that?
Yes, ma'am.
Okay?
Yes, ma'am.
All right. Scott, lean back. He probably shouldn't be here either. Right?
It's a medical research, ma'am.
Lean back isn't, well, he doesn't need to, lean back is all violation of probation.
We have Mr. Pierce here, and he's ready to proceed. At this time, he is, again, declined the services of the public defender.
All right, so on lean back, I find probable cause. He has a status hearing with his division judge. It's all violation of probation with no bond holds. Okay. All right, and Mr. Pierce.
Yes, ma'am.
Sir, you are before the court this morning for one charge of touch or strike battery. Number 2 is resisting officer without violence. I find probable cause. All right, state.
Okay.
Judge, he does have a couple priors of burglary in 2008, trespass and resisting 2016, a number of other resistings in 2017.
Okay.
The state is fine with the bond amounts already set, no victim contact.
All right. Mr. Pierce, you have $1,000 bond. And I'm ordering no victim contact, which means no phone calls, no text messages, no social media, no third-party contact.
To who?
The victim with the initials LR.
LR? Who is that?
That's the person who lives across the hall from you in your apartment. Okay?
That's who called the police on me?
All right, let's go to the next person, Demetrius Randall.
Mr. Randall is present, Your Honor. We're ready to proceed.
All right, Mr. Randall is before the court. Charge 1 is robbery, no firearm or weapon. Number 2 is battery, second or subsequent offense. And I find probable cause for this charge. These charges. All right, state.
The state is asking for $7,500 on count 1 and $1,500 on count 2.
Okay. Mr. Goldberg?
Sure, Judge. Mr. Randall has lived here in South Florida for the last 35 years. He lives in Deerfield with his aunt and his nieces. He's not working right now. In addition to the aunt that he lives with, he has another aunt here in Fort Lauderdale and a sister in Plantation. He's asking for bond less than what the state is seeking.
All right, I am going to impose a $10,000 bond on charge number 1, and on number 2, he has a $2,000 bond. No victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Okay. Joseph Roth.
Mr. Roth is coming up right now, Judge. Here he is.
All right, Mr. Roth is before the court on one charge of touch or strike battery. Number 2 is a criminal mischief. Number 3 is a violation of felony probation, and that already has a no bond hold and is not for magistrate. I find probable cause, and you have a $1,000 bond on 1. It looks
Thank you, Judge.
the VOP is out of Monroe County.
Victim contact?
No victim contact. Mr. Contreras,
He bonded, Your Honor?
okay. All right, I find probable cause on Maker Contreras, who bonded. Clifton Smith.
Bonded, Your Honor?
Mr. Smith bonded. I find probable cause. Devontae Williams. And Mr. Williams is before the court on one charge of aggravated assault on an officer or a firefighter. Number 2 is violation of community control. That has a no bond hold. And you will see your division judge tomorrow morning at 8:30 a.m. I find probable cause, and you have a $1,000 bond on 1. I'm sorry, a $2,500 bond on 1. Okay. And then Alberto Salas.
He refused, Your Honor.
Mr. Salas refused. It
So
looks
I'm
like
told.
before there was a medical reset. And so today there's a refusal, so we will reset one more time. We'll see what happens tomorrow. Okay? All right, thank you, everyone. I think that's it for the morning docket.
Thank you, Judge. Happy New Year.
Same to you. I'll see you at 1 p.m. Well, you know. Afternoon, everyone. It's Judge Jackie Powell, and this is first appearance court today, this afternoon. I'll let you know if I've determined probable cause from the reports I read this morning, and then we will talk about release conditions. Today's not your trial date, so I encourage you to speak with your attorney before speaking on the records. Everything in this courtroom is being recorded and can be used against you at a later time. Because we don't have our regular attorneys, will the attorney for the state please announce?
Michael Spear on behalf of the state.
Thank you, Mr. Spear. And then over at the main jail,
Julie Chase.
thank you. All right, and so we have Sabrina Pago. All right, ma'am, you are before the court for charge 1 is possession of methamphetamine. Number 2 is possession of drug paraphernalia. Number 3 is failure to register motor vehicle. I find probable cause. I'll hear from the state if you wish to be heard.
Heard of Your Honor.
No? All right, so Ms. Chase, she has $1,000 bond.
Judge, it's my understanding that she doesn't have any significant priors. We were hoping that maybe she could be RLR'd on this nonviolent third degree. She's lived in Broward County for 35 years. She has a grandmother and baby as well as other family. Part-time work as a receptionist at an electrical company, although it's not a steady income. She doesn't have much money in the bank. If the court would be so inclined.
Does she have any priors? Right. Okay. All right, apparently she has other pending drug charges in Palm Beach. So I'm gonna leave the bond at $1,000, okay?
Okay,
Thomas Corness.
Judge, if I may, I did speak to her just for the record. She says that when she went to court on a paraphernalia charge, there were charges showing up under her name that are not hers.
Oh, we can't resolve that here at this point, so she has $1,000 bond. Thomas Corness. I don't remember. What did you tell me this morning?
And you said you're going to have you come in on the record, say if you have any weapons, because they won't release it.
All right, Mr. Corness, was before the court. I don't know what date. December 17th. And at that time, there were several conditions that were put in place in regards to him posting his bond. There is a condition that he must surrender weapons before release. And so he has been put on the docket for us to make that determination at this time, because apparently the bonds have been posted, and the only thing that's holding him up is the, whether he has any weapons or firearms to be surrendered.
I don't.
All right, sir, I'm gonna ask you to raise your right hand. I'm gonna put you under oath. Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down. I'm gonna ask you to state your name for the record.
Thomas Corness.
All right. And Mr. Corness, do you have any weapons or firearms that you need, that you have at home somewhere or anywhere else?
No, ma'am.
All right. All right, confinement and pretrial. All right, so we'll sign that order, taking that condition away. Okay? All right, that's it for, so we didn't even need to, we don't need this, because we already found probable cause. His bond, he was only put on for that condition. So I don't think, if someone will the state draft the order, if the confinement will let him know what the condition is. I'm sorry? Yeah.
Judge, that's the only thing holding him at this point is that condition which
Right,
we're deleting.
right, we had that conversation this morning. His bond has been posted, everything else has been done. That was the only concerns that they had. That's right, that's correct, right? His bonds
Yes, his
were
bonds have-
posted, okay. That one condition about the.
The surrendering of
Yes,
weapons is deleted.
yes. Just based on the testimony of the defendant, that he has, yeah, okay? All right, you're welcome. Qlen Perez. Last name Perez Qlen. Yes, Noel Perez Qlen.
Quillan, yes.
Okay, Mr. Quillen is before the court, one charge of driving while license suspended. Number 2 is unlawful speed. That's not for magistrate. And also there's a writ of arrest that's not for magistrate. And then there's a misdemeanor KPS. That's also in place. That KPS is from 2013 on a possession of controlled substance.
Judge, it appears that Mr. Perez Culon has been county sentenced on count 3,
Okay,
but I don't know what
on
sentence he
3?
received.
Not 3, on 3
On
is
the writ of arrest.
Okay. Mr. Perez, did you resolve the writ?
Judge, my understanding, he hadn't been before the court on that writ. I know sometimes with the child support, it's an either or, like they can pay the purge or they're in for a certain amount of time. When I spoke to him, he hadn't been in front of a judge on the civil writ.
Okay.
How long was he county sentenced until, does it say? On from 6 months, I think.
Okay. All right, so he hasn't been before a judge. All right, so I will, I'll leave the bonds in place then. And, it says that he has a status hearing tomorrow at 9 a.m. Okay? All right, Iram Domingo.
Reset?
Reset. Okay. Well, well, okay. Sean Inman.
Yes, ma'am.
Judge, he's approaching.
Reset on the.
Yeah.
You're fine.
Okay.
All right, Mr. Inman, you're before the court for one charge of possession of cocaine. Number 2 is a traffic infraction. Number 3 is a civil writ. And I find probable cause.
Yeah.
Judge, my understanding is he doesn't have a place to stay with no money in the bank. He's had a stroke within the past year and neck surgery. I know he has this writ for $261 if the court would consider ROR on the possession.
What kind of, does he have a criminal history?
Yes, Your Honor. The most recent Broward, he had an attempted robbery with a weapon in 2009. He was sentenced to 40 months prison on that. In 2000, he had a grand theft and an uttering a forged instrument. He was sentenced to 364 days county jail on that. Several other misdemeanors throughout, and had previously also been to prison back in 1990 and 1991.
Does he have any history with pretrial? Okay.
Counsel saying he doesn't have a place to stay, that might be an issue with the trial.
so Mr. Inman, I am going to leave his bond at $1,000, okay? Keith Duran. Mr. Duran bonded. All right, so Mr. Duran bonded, and I find probable cause. And Brendan Zambrand.
Bonded.
All right, and Mr. Zambrand as well, I find probable cause. Do we only have one hearing docket? Just that? Okay. So, counsel, you're here for Robert Johnson? Robert
He's in-
Johnson?
He's in Paul Ron, Judge. They were bringing him, I don't know if they have him yet. That looks like him.
All right, so Mr. Johnson was arrested on November 18th. Is this a 30-day motion?
Yes, Judge. He's actually been in custody for 45 days. No information has been filed by the state, so we're asking for him to be ROR.
Okay. All right, so I'll sign the order granting the ROR. All right, and Mr. Johnson, you need to make sure you stay in touch with your attorney so you know what's going on.
Yes, ma'am.
He actually
Okay.
has a hold in Indian River County, so
He
he'll
does?
probably be transferred up there.
Okay. All right, thank you. All right. Yes, sir. Taekwondra Collins.
Oh.
Okay. All right, Ms. Collins, it appears that there's no need to have this hearing because your bond has been posted.
All right, thank you.
All right. And Cedric Coney. All right, Mr. Coney was arrested December 29th. How much bond is he on? Do we know? 1,000? Okay. And does he have any criminal history? On Mr. Coney? Or can I see the probable cause affidavit? Okay, thank you. Yes, Ms. Chase?
Judge, at this point, we're requesting a phone order for him to be able to get to his contacts and be able to call someone to help find him out.
All right, I'll sign that phone order.
I didn't hear if there was a prior history. I couldn't hear very well over here.
I think there was a, you said that,
Drug priors, 2019, possession of cannabis, 2018, possession of
he does have drug priors, 2019, 2018, PVP, and other drugs, okay?
Your Honor would consider ROR, we'll just leave it as is.
Yes. All right, so I'll deny any ROR, he still has his $1,000 bond. And I'll sign that phone, order allowing him to access to his phone. All right. Is that it for our dockets? Yeah? All right, thank you, everyone.
Sorry, we have one other person here, Roderick Thomas. Is he not on the docket? It says they're telling me he's scheduled in the computer, but he's not on the docket, so I don't know what's going on there. But they brought him since he's in the computer.
Oh, I have no paperwork. I have nothing that says why he's here.
Sounded to me like it could be a 30-day motion because he's been in since October 30th, but other than that, I don't know. Oh, and also he's saying it's his fourth time being brought back here this week, and it's the same thing, so I don't know if Odyssey shows him up having a court date.
All right, can we, double, what is his name?
Roderick Thomas,
How do you spell it?
Roderick ThomasRoderrick.
Wait, what other information?
You have his number, can I see? We have his arrest number, if you wanna sit down, have a seat. If you wanna look him up, this doesn't have a case number, date of birth. Doesn't, where is it? 1793. And the arrest number 571-905-201. Have a seat, let me just.
Does anybody have anything? No, but I'm asking you to look him up and see what's going on with this case.
If someone could just check the clerk system to see if there's a court date scheduled, because I can't do that from here.
1793. Yes. What kind of hearing does he have? Oh, Barbara. And January 16th. So he's scheduled for a calendar call before Judge Duffy on the 16th.
Okay, thank you very much.
All right. Thank you.
Oh, they come here?
Yes.
Okay.
Right? They come
They're not
here.
recorded.
Yes, so it's not recorded.
But everyone else is.
But everyone else is.
So on is system
So-
off,
and
system
you,
on.
And you know when it's on, so you see, you can tell, but you see the camera
Yeah.
over there? So that's how, when you press